Hi, good morning. This is Attorney Amy Rafeka, and we are at Atlanta Wills and Trust this morning, and we are live for episode 2 of Wills on Wednesday. We are really excited today to talk about a question that I receive a lot during consultations and through the planning process from single parents. And this is can happen in a situation where a single parent has never been married to the biological father of their children, or they're either going through a separation or a divorce, or a divorce is been finalized. And many times I'm presented with the question of, well, what happens to my children if I pass away? Is it automatic that their biological father will get custody of them? And then there's a second question as well, which is, if their biological father receives custody of a minor child, a child under the age of 18, if I pass away, is it automatic that he would also receive and be managing any money that I may leave my children if I pass away? So these questions are presented to me a lot during the estate planning process. And so one of the things that I always respond to someone is that if you don't put your choice about what you want to have happen with your minor children, what's in their best interest if you were to pass away, and who it would be in their best interest to live with, in writing, in an estate plan that makes sense. So it's presented in a way in the documents that it makes sense. If you don't put your choices in your estate plan and in your documents, then your choices will never be heard, and they will never be part of the process of deciding who it's in your best interest or your children's best interest to go to. So absolutely, what happens when someone passes away and they have minor children is that a decision does need to be made. And there is an official decision that needs to be made, and it's typically made through the court system. Almost always, no matter what state you live in, there will be a court system involved if someone passes away and they have minor children. So in the state of Georgia, that court system is typically a probate court. And occasionally it can be a different court depending on exact situation, but a probate court would be involved. And who sits over a probate court is a judge. Male or female, a judge will make these decisions ultimately for you. So what I always talk to my parents about, who are sitting across the table from me and are coming to the realization that, this is a real thing and it could happen, and they need to make decisions about what's in their children's best interest if that were to ever happen, is that they have to put their choices, they have to put the reasons for their choices, and any other thing that they think would be information that would be important for that judge to make a decision about their children on a day where everyone is going to be very emotional. If they want the judge to know this information, they need to put it in writing. And that's what an estate planning process can do for a single parent who has full custody, joint custody of their children, is put it in writing, put your advocacy information in writing, whatever you would say face-to-face to that judge if you had a chance to. Of course, you are passed away, but you wouldn't. But whatever you would say if you had an opportunity to that judge, let's put that information in writing so that that judge knows what you, as the parent of that minor child, believes is in their best interest. And that's what an estate planning process can do for a single parent. I think it's critical that any single parent, no matter how involved the biological parent, other parent is, should have an estate plan. And the estate plan should address several things relating to your minor children. But the most important part of that plan really needs to address, what are your choices as to who your children should live with on a daily basis? Who should be deciding what your children eat for breakfast? Who should be deciding where your children go to school? what brand clothes they should wear that day to school. Who should be making those decisions for your children if you can't? And when you have the situation, the family situation where you're going to have two households, two biological parents stepping, that there is that dynamic that happens in that relationship, you should really put in writing what happens. So these are the kinds of things that I help single parents walk through, these kinds of decisions about how to put it in writing, which documents that information should go to, and how it should be presented. And once we do have it in writing, what does that parent do with these documents? How do they tell their family to advocate on behalf of their children if something were to happen to them? So this is Amy Rafeka. We talked wills on Wednesday today about what a single parent, how a single parent should make decisions about what happens to their children in the event something were to happen to them, and what does happen and how they can plan for it. That's our topic of discussion today. So thank you for joining me for Wills on Wednesday, episode 2.